Amy, are you there? Good morning, good morning, good morning. Baby, I will be at Michelle and Anope. What's today? Today's Monday, 8th of August. The time now, 17 minutes past 10. And Anope, GN Radio Legal Hour near the Brewery and the Abinelle Solicitors for better train come. One more area of speciality, immigration law. And family law. And if you have any issues that you need the help, make sure. So you call in. Why? Ubeti me afre. Na o concerns you now no more ha umeboa. Meant now on mo enye. Say oh me meet me aye and I say madam for be quiet and say any buy. Otherwise, before you realize, no, things will be too late for you to do anything. Well, if not too late, crumple now. Maybe the price might be more, more than if you would have seek their help initially. Meant now no more. And now I say, Ibia, Ubia I go through the same, your friend is saying, issue we need help with. be in the background or no, it's me and Nadia. But your case might be different. Need to know. Don't sit at home thinking you could do things by yourself. It's always important to seek legal advice when it comes to immigration law and family law. And the only place you need to look no further than Abinelle Solicitors. So now no pay any on I mean for my address and to my address A 14 Claypole Road, Stratford, East 15. That is E15 to RJ to Romeo Juliet. My office line here 0203 759 3309. And on my mobile line is here 078 247 05353. 078 247 05353. Into the share numbers. Now from meant now. And the last time I remember Amy now on the issue of trust came up, and for me, that is huge. Because a lot of the times, we've heard of horror stories. Say, being here, say, immigration papers once. Now, if you lawyers be on the back, and solicitors be on bedje, a friend say, okay, no, but Sika on bed charge, no. Making the case, no money on you. Now they be out as a cobra, son. I will be not near my cage. Into no men, yes, sir. Abinelle Solicitors, dear. Now, do a more on bebwa. Meant now, and my documents and could be coffee they be a cobra, and then one story, another time, different stories. Into no making sure, sir, we get in touch with Abinelle Solicitors. Sabano, immigration law and family law. Abinelle Solicitors for and on me abwa into making sure. So in that program, yeah. Says stream live on Facebook. Into more Facebook, Mr. Mahmudu and share. Why? Moon share. Moon share my I feel message being so bit me so age message no Facebook na area to Amy and him from Abinelle Solicitors not with me one. Okay, let's move on. I'm saying Amy Adjanian. Amy, good morning.
Morning, Jones. It's saying,
Yeah, me Adam background well. And I know paid here. You better about transfer of tenancy. And but before I remember on I may kite for so bit me afraid. Studio line of 0203 735 8820 and I said 0203 286 0185. Alternatively, Fred mobile line and I saw person sending message and swear ubit me a coin 0778 793 9958. Mr. Wa Shannon Bezin so now be a chewa dream be a ubit me a friend Amy etimi abwa. Eka transfer of tenancy. What is it exactly?
All right. Jones, transfer of tenancy, exactly how it says what we've mentioned, is a tenancy agreement. And what would be demo? Due to change in circumstances, okay, so sister demo about woo demo. And nona, it is a family law application, and now more friend of transfer of tenancy. Transfer of tenancy.
Okay. All right. I'm sure it's a friend's name for Bia Betiasi. Anyway, so what type of tenancy agreement exists in the UK?
All right. So with the UK, tenancy agreements that exist, for example, we have the fixed tenancy agreement from a private landlord, for example. We also have the local authority, housing associations. Those are the type of social landlords, secured tenancies, assured tenancies. these are the type of tenancy agreements. I will say, Jones, sometimes to me, who nipa omukasa media housing for a mom dino. It might be a housing association. Sometimes somebody will tell me, so me were landlord, me were landlady, or no mom, me tenancy agreements, and no na your friend a private landlord, or no air renting a property, that sort of thing. It could be say crown or subletting. Until no crown a tenant, but or sign the letter, or also unya home tenancy agreements, and then there are different types of tenancy agreements in the UK.
No be just say ain't no Van says in Pacrono aware or just aware and I face no that tenancy agreement no or no ni dim.
Yeah.
Now after divorce no, what will happen to the tenancy?
Well, after divorce, no, if for example it was in your sole name, if you answer na more worrying tenancy agreements, no, now what nipa bakunsem. Yes, that one after the end of the marriage, of course, the tenancy remains with the sole tenant. No, what tenancy agreement more dada. So that is really what really happens, unless of course there are some circumstances via it will dictate, say, yeah, I mean you would want the tenancy to be transferred. If Krona dine crown team what two coin, the dam is empty. Ebia crana not one color in colano so money baby tenancy agreement baby mutiana mutina na convenient man colano ebe boa the welfare of Nkolano. And then the family court will look into that to make a decision as to whether that tenancy agreement whether it can be transferred to the other party's sole name. Yeah.
And since CBA work in the issue of transferring, so transferring tenancies for the benefit of children in the Pacronum ABC. But the key elements the court would like to examine in order for the transfer to happen. What are some of the key elements here?
Okay. So there are a number of elements. First and foremost, who is on the tenancy agreement? Say, let's say for example, tenancy agreement council Mamodai, but tenancy agreement Nankasankasano. Obadin ewoso, and I say Bemadine ewoso. Say no, mu pese, muba ku pese, yet transfer tenancy no back omudimo. It is possible, but remember, say first and foremost, no, the court will put the other party on notice, say, who try to obey sa application, no. So because you are the applicant, no, number 7 with copies of those documents, transfer documents, no. Application forms, no, number 7 with copy to let them know, said this is your intent. Upe said, sebe uji dino eshe wa udimo. That's the first thing. But proceeding to court, no, there's particular things that they will acknowledge. One, whether both parties are within the property, they will assess that. 2, whether the party or everyone on one demono or krumha and now only krumha or what dynamo or timu and I say Nidin was so keke because as you know, Jones, Nipa Bibrewo almost say, oh yes, right, omo only dino, but they don't live there. Into best assess that. They will also assess the needs of the children. Of course, this is where the welfare of the children comes into play. And the needs of both parties. They will feel, say, okay, then it will be more appropriate. They will also assess your finances as well. Just so that if one person, every tenancy agreement, so now transfer more, and also obenya baby adana, obenya alternative accommodation and in same way when in yana courts no ever consider now they'll take into consideration. Yeah.
It's what if says depends on private ownership or nipakura within the family be or banning a Daniel India as a bearman Daniel. Let's say it's a bearman and Daniel India. What will happen? The relationship breaks down.
Okay. When you say what would happen,
In terms of tenancy agreement.
how it will be dealt with once the relationship is broken down.
Yes.
Yes, I mean, it would be up to the parties involved, especially if the party is not on the tenancy agreement. It would be up to them to consider whether, in fact, they want to transfer that tenancy in their name or not. Often there would be a need, but people don't know how to go about it. They would actually want it, but they feel they don't have the right. But you may have the right. You need to come to us, have a sit down. We'll have a look at your circumstances holistically, whether there are any children, your financial needs, whether there's alternative accommodation for the party you want to exclude, or you want the transfer, from the party who is transferring the property. You need to know all of this information before you can make a sound decision as to how to go about the application.
What about in terms of child arrangements on a breakdown of relationship and so on?
Child arrangements in the breakdown of the relationship. Yes, if we are talking in terms of the transfer of the property, of course, the family court will always consider as the overriding objective the welfare of the child. That's the one of the family court's number one principle. They look at the welfare and the best interest of the children. So children who are under the age of 18 and are minors will be considered favorably in such, an instance. They'll look at the children's needs. Maybe where that tenancy or where they are currently residing, maybe it's convenient for the children to live there. They have adequate rooms that they live in. Maybe it's within close proximity of their school and their friends and their community. The judge would not want to, forcibly remove such children into a completely different area to inconvenience the children. What they would ask and what they would assess is it within the best interest? Is it, is the welfare principle being considered here? And Jones, with children in particular, they take, take it with the utmost importance that children and their welfare is paramount. So these are things that they will consider in respect to child arrangements.
Okay, I have a text message from Francis here. Francis is saying that the relationship between me and my partner, the relationship between me and my partner has broken down. We have a 2-year-old, and my partner is refusing me from seeing my child. What steps do I need to take to be able to see my child?
Okay, so first and foremost, the family courts in the United Kingdom always want you to try and use ADR, which is alternative dispute resolution, to resolve the issue first and foremost. So the first point of call is to see whether you can discuss it with your partner or ex-partner. If that fails, the next step would be to actually go through mediation, which is a requirement in the UK when you're dealing with family law cases, when you're dealing with children, to try and mediate first, which is called the MIME, try and mediate to see if it can be agreed at that point. If it can be agreed at that point, yes, fantastic. It means that you have resolved the issue. Of course, once you resolve, you want something set in stone. When you come to Abinelle Solicitors, we'll be able to help you with that. Make sure that it's set in stone and it's legally binding, which means that it's not just that the mediator has agreed it between the parties, and after that day, the following day, your partner's mind can change and she'll say, or he will say, no, I'm not going to let you see the children, although it's been agreed. There's a way to formalize such agreements with the family court to make sure it's set in stone. So we can help you at Abinelle Solicitors. Please take our number and give us a call, and we'll take you through a consultation, letting you know what the procedure is.
And the number is into normal office line, Abinelle Solicitors office line here, 0203 759-3309. And I said 078-247-05353. 078-247-05353. Another text here from Mami Jennifer. Say, I don't have my documents here and I've overstayed. However, my husband is threatening to throw me out of the house. Please, is there any help for me? Wow.
Okay, so does not have her documents and she's overstayed, and her husband is threatening to throw her out of the house. Okay, so Jones, in this instance, with under the immigration rules, there's sort of minimal protection, really, because if she was here, let's say on a spouse visa, whether it would be under the UK laws or the EU law, if it would be, then there would be an advantage there because you have that protection under Appendix EU. You can retain your rights because of domestic violence, or under the immigration rules, you can also make a domestic violence application for indefinite leave to remain. But as she's an overstayer, it might be quite difficult. However, Jones, I would want to speak to her to know her full circumstances, to know everything about her case. Maybe we can advise her for her to regularize her stay on another route. So if she can kindly give us a call, we'll take her through the necessary procedure.
Mami Jennifer, so please do call 0203-759-3309. 0203-759-3309 or 078-247-05353. Let me repeat that again. 078-247-05353. Call Abinelle Solicitors right now so they'll be able to help you. All right, now on the subject of relationship, Amy, are parents allowed to blackmail each other once the relationship has broken down in respect to their immigration status?
Wow. No, James. Actually, it's definitely not allowed, but it's something that happens on a regular basis, because people use it as like a bargaining power, a way to bargain, oh, if you do this for me, I'll do this for you, that sort of thing. But really, it shouldn't be so. And I think that anybody who's being blackmailed and being threatened with their immigration status should always come and see us first. There may be a way around, settling this, whole dispute or disagreement. Let us know first. It shouldn't be so anyway, Jones. It has to be. It's pretty straightforward, and there's certain things you have to do to make sure your immigration status is not harmed or goes unharmed. So there's certain steps you can take.
I think we had this question last week. So this is from Mami Adjua. Mami Adjua is saying, last week, well, she said it. Last week I caught the tail end of your discussion about fee waiver. Please, can you explain who can apply for fee waiver?
Okay. Right. So fee waivers, you can do both entry clearance fee waivers, which was introduced recently, or in-country applications. You can make for certain applications anyway. With entry clearance, you're looking at any application for leave to enter based on human rights. So it could be under Appendix FM, it could be that your parents have 2.5 years here and they want their children who are minors to join them in the UK. Then yes, you can make an application for a fee waiver there. It might be under the spouse route, for example, for Appendix FM again, the 5-year spouse route or 10-year spouse route, and you want to come into the UK, you want to travel to the UK, you can also do a fee waiver application for you on that basis. However, if you're looking at in-country applications, you're looking at further leave to remain. Leave to remain is a wider scope. So if you've lived here unlawfully for 20 years and you're applying under the private life route, you can apply for a fee waiver. You can apply for a fee waiver for the partner route or the parents route, both the 5 and 10-year routes as well. You can apply for fee waivers. So that's it. Sometimes I think people get it mixed up. When it comes to settlements in the UK, both in-country, making an in-country application to settle in the UK, there's no fee waiver there, okay? Also, in respect to entry clearance, if you're making a settlement application for your child under the paragraph 297, the rules, you can't make a fee waiver application there either. Neither can you do it for naturalization as an adult. However, you can also apply for a fee waiver for registration for children, for example. So when your child is 10 years of age and you want to register the child as British, you can apply for a fee waiver on behalf of the child. So these are the sort of applications you can apply for fee waiver for. The rest of which has not been mentioned, EU applications are normally free. But any other applications, settlement, naturalization, skilled worker, and so on and so forth, you would have to pay the requisite fees, student visas, and all those things. You have to pay the requisite fees for it.
And the fee waiver, I think that last time we spoke, you touched on some requirements that needed.
Yes, you see, with the fee waiver, Jones, I think on a regular basis, people are getting the concept and what the requirement is wrong, okay? The fundamental point that the Home Office or entry clearance officer would be looking for is they would be looking to see whether the applicant in question meets the affordability test. So you have a lot of people asking and making inquiries. They'll be like, okay, Amy, I'm earning £2,000. I'm working. My wife is working. So how do I qualify for a fee waiver? I thought that was for people for asylum, or I thought that was for people who are unemployed and are on benefits. It's not just for them. So it's whether you meet the affordability test or not. Now, what is the affordability test? The affordability test is the Home Office and entry clearance officer want to have a look at your financial circumstances to see whether you indeed you can afford to pay the fees. So despite whether you earn £3,000 or you have a £5,000 household income, they are going to look at your income and expenditure to make their decision overall. So if you have a household income of £5,000, but you're paying your mortgage, you have your utility bills, as you know, Jones, the cost of living is up at the moment and things can be quite difficult. So you have to pay all of these, sort of outgoing costs. At the end of the month, you have very little or nothing left in the account. The question is, can you afford the fees at that point? It's arguable. You may have savings in another account and it may have 10 or 15,000 pounds in there, whether it's you or your partner. Then again, they ask the question, can you afford the fees? The answer to that would be yes. If you have savings or you have maybe extra income that you've not disclosed, for example, then you can afford it. But if you are in the first person's predicament, you take out all your living costs, your outgoing costs come out and you have nothing left, or you have very little left, over a 6-month period, it's the same pattern because they ask for 6-month bank statements. You're living hand to mouth, although you're earning this sort of money, then it may be, it's not definite, nothing is definite, but it's a discretionary assessment anyway, based on the evidence you provide. It might be that your fee will be waived.
Okay. I'll take note or person from us after the show now, please do so on these numbers 0203 759 3309 or 07824 705353. Kwame is asking, can I invite 2 people simultaneously?
Yes, you can. There's, of course, is it for a visit? You're inviting them coming to visit you in the UK?
No, that was his question.
That was his question. Okay. Let's say, for example, it's a visit, providing
okay.
the applicants in question are able to meet the
Back
rules,
to
they're fine, but the rules are very important in this case. If they're able to meet the rules, such as you satisfy the requirement under the genuine intention to visit, you're able to maintain and accommodate yourself adequately without any recourse to public funds. These are some of the requirements. If they're able to meet it, it's fine.
Okay. Another text message from Joyce. Joyce is asking, I'm looking to invite my cousin here. This is my first time doing such a thing. What should be included in the invitation letter? Okay.
Sorry, James, if you can kindly repeat that question.
From Joyce. Joyce is saying, I'm looking to invite my cousin to the
Yes.
UK. This is my first time doing such a thing. What should be included in the invitation letter? And I think she also, yeah, I didn't read this part. And what documents do I need to show?
Right. So, okay, that's a very good question. It depends. If she's the one who's sponsoring her cousin financially, then there's certain documents she would need. Also, your cousin as an applicant would also need to demonstrate that, one, they meet the validity requirements. So he has a Ghanaian passport, a valid Ghanaian passport, or whichever nationality that they are. They would have to have a valid passport. Also, they would have to enroll their biometrics. So once the application is submitted, wherever it is, they would need to enroll their fingerprints, take the fingerprint data and everything. But going into the requirements further, they would need to make sure that there's certain aspects they satisfy, like the genuine intention to visit. Jones, this is where a lot of people fail. They fail on this point because they can't really demonstrate that indeed they're coming to the UK to just visit and then go back to their country of origin. It's always that question sometimes is always left unanswered. So what I would tell her, Jones, is if she can give us a call, I can take her through all the requirements and help and assist her to make sure the application is a success. So she should definitely give us a call and come and see us.
All right. This is a message from Emmanuel. Emmanuel saying, please do you provide sponsors for care workers and nurses?
Okay.
Do you offer the required English test lessons
provide
as well?
Sponsors for care workers and nurses. However, if you are able to get a sponsor and you need help with the immigration application in itself, we can then assist you to make sure your application is successful, so we can do the immigration side of things.
Right. Also asking, do you offer the required English test lessons?
Do we offer English test lessons?
Yes, that's what they're asking.
No, we don't. We don't offer English test lessons. But I can assure everyone who's listening that if you are thinking of going for an English language test, or you have any family members or friends who are interested in doing so, it's speaking and listening for the skilled worker route. It depends anyway. If it's the carer route, it's speaking and listening, and it's pretty straightforward. So you shouldn't really have a problem, to be honest, with the English language test. If there's any other sort of questions they may have, they can always give me a call, and I would assist them.
Right, do so. The number you need, or numbers I should say, is 0203 759 3309 or 078 247 05353. Abinelle Solicitors, do get in touch. Now, William is asking, I want to invite my sister to work here in the care sector. What do I need? What are the requirements?
Right. So, you see, first of all, William wouldn't be able to invite her in his own right. She would need to search for a job with an organization that have the Home Office sponsorship license. She would need that first and foremost. So once she's able to secure the job, of course, there's certain requirements that she would need to meet under the skilled worker route as well. So in terms of what the job requirements are, that would be down to the care home itself. But in terms of the immigration application, there are also other requirements that need to be met as well. You know, what I would always say to clients is definitely, give us a call, come in for consultation. We can then advise you as to what to do, what documents you need, what the requirements are, and we can take you forward and make sure your application is a success.
William, so do get in touch. Again, the numbers are 0203 759 3309. Alternatively, you can call 078 247 05353. If you need to go and see them, Abinelle Solicitors, that is. The address is 14 Claypole Road, Stratford, East 15. That's E15 2RJ. That's 2 Romeo Juliet. So do not sit down there. Make sure you get on board and you go and see them. For some reason, okay, so we'll get Amy back. Don't worry, Amy will be back very, very soon. For some reason, she just disappeared now off screen, but Amy will be back. So, as I was saying before we started the conversation, you don't want to waste time and resources at with some banks, your friends in your banking pool, with some solicitors. Yeah, it will cost you dearly. And to know the best thing to do is make sure you get in touch with Abinelle Solicitors. Very friendly, welcoming, and most importantly, they're there to help you to find solutions to your problems. So do get in touch. Okay, glad to have you back. Emmanuel is asking, how much is it for consultation, Amy?
Right, our consultation fee is £70.
I
So
think
not much, just £70. Just
okay. £70, Emmanuel. £70 is not much. So do make sure, trust me, it will be all worth it. So do get in touch. This is from Jude. Jude is saying, I am with my partner on a student visa. How can we get ILR after postgraduate visa for 2 years, which total 3 years?
All right. So yes, I mean, what I would always suggest in such a situation is you should try your very best, possibly to maybe switch to being a skilled worker, because when you do switch to being a skilled worker, there's a potential to settlement there. But if once the graduate visa expires, it can be quite difficult. So whilst you're within the rights to be on your graduate visa in the UK, I think you should look for the alternative routes that would eventually lead to settlement. And I think a skilled worker route is a good route, especially being educated and you've graduated, maybe for master's or from your undergrad and you're doing something else. With that level of education, there may be a possibility that you may have a job as a skilled worker. Always look for jobs that have the Home Office sponsorship license, and possibly maybe on this occupation shortage list, Home Office occupation shortage list as well. Look for jobs within that field, and then hopefully you should eventually be on your way to settle in the UK.
All right. But can parents outly refuse to put a parent's details on the reals at school and GP?
Wow, Jones, that is such a good question, because parents are doing it, these days. And obviously, Jones, in such a situation, that if you're not on the records for the school or GP, it creates complications, because if you have a British child, you need to demonstrate that you have sole parental responsibility for the child, and you are actively involved in the child's life. Now, where it has to be an attested document or confirmation from a partner or an ex-partner to confirm that you are involved in the child's life, sometimes you are met with difficulties, because the person may decide, no, I mean, they're not going to information or anything of that kind, So you can't outrightly refuse to put somebody on the child's records. Once you have a birth certificate, you also have to remember that you have parental responsibility. That's what people call, and that's what the law calls PR. You have parental responsibility for that child in particular. So if you're able to provide a copy of the child's birth certificate, and even though the other parent is trying to deny you access to the school or GP, once you take a copy of the birth certificate to any such institution, your hope of being, on the child's record is, of course, that's renewed. You get that, that opportunity, that chance. But if you do nothing at all, or you just walk into the school or to the GP, they're going to think, well, who are you? Do you even have parental responsibility for this child in the first place? So we need to know our rights. We need to know our rights within the community, know what we are entitled to and not what we are not entitled to. And then we then know how to act accordingly. It's very important.
No, I agree, because there have been cases, within the community where, relationship has broken down. Mother or the former partner has moved out, and the mother has said to the school, the father should not be allowed anywhere near the children.
Yes.
But in a case where there's been domestic abuse, for
Yes.
instance, how would that play out? Because clearly the father will want to see the children, and the mother's opposing to that. How would that play out?
Well, you see, Jones, there are things that are reported, there are incidents that are reported and incidents that are not reported. That's the first thing, to the police or any interested party. And also, if there is allegations of domestic abuse, the family courts have a way of dealing with it. You can apply for a non-molestation order and an occupation order. Once you don't have that in place, it's a mere allegation you've made. It even at that point in which it goes to court, it's an allegation that's been made. If of course the court find that you should be protected, they'll give you a non-molestation order. So we have to remember that just saying that there's domestic violence, you're not going to let the parent see the child, is not good enough. Now, even if the parent has a non-molestation order in place, we have to remember that these are allegations, and if the accused party goes that step further to make a child arrangement application to see the children, and there have been allegations of domestic violence, the family courts have a very good way of settling that dispute, because what they do is they have a fact-finding hearing to determine whether indeed the allegations are founded or not.
I might just have to interject quickly, because we have a caller. Hello.
Hello. Good afternoon.
Good morning, sir. Well,
sorry,
good afternoon, probably from where you're calling from.
No, I think it's my fault.
No problem. What would you like to say, sir?
Good morning. I'm calling from Birmingham, and I have a question. I'm a Ghanaian, but I have British nationality as well. I got married in Ghana. It was customary when I did not attend because of COVID. That was in 2019. I did application to the Home Office, but my lawyer made a mistake. I'm a self-employed. He sent only 6 months bank statement, but was refused because of my income. I appealed. The marriage was approved by the court that the marriage is genuine, but the income was not enough because he didn't send much of my bank statement. Now, my problem is that I want to reapply, and I've seen the lady, so I want to go to her. My question is, I've not been home since 2019, and the marriage certificate, the court has I said, is genuine. But can I do the application now, or because it's too long, I have to go to Ghana and see my wife and come back before I do it?
Thank you.
Yeah.
Thank you. Not necessarily. You don't have to go back to, if you've already made the travel arrangements, fantastic. And you can afford to go back, wonderful. Then you can go back to Ghana. But there's no actual requirement that you have to travel to Ghana. The requirement that you need to meet is the relationship requirement. There's something called intervening devotion. Intervening devotion means you're not actually together, but you're able to demonstrate that your relationship is genuine and subsisting. Now, how do you do that? WhatsApp communication, call logs, messages, money transfer receipts, door-to-door receipts. So there's a lot of ways you can show your love and affection and show that your marriage is genuine and subsisting besides actually traveling. As I said, if you've traveled already, that's no problem, or you've traveled in the past, we can still use your travel history as part of your intervening devotion and as part of your genuine and subsisting marriage. We can use that. But you don't have to necessarily travel back to Ghana if you're able to prove that you contact and communicate your wife on a regular basis.
All right, Amy, thank you very much for joining us today. As always, pleasure to have you on the show. Well, there you have it. We've come to the end of the show. This was GN Radio Legal Hour with Abinelle Solicitors. If you want to get in touch with them, you can do so. 0203-759-3309 or 078-247-05353. We're done for another day. All being well, we'll see you next week. Before I sign off, let me put the address on as well. So if you need to go and see them, okay? I'm sure when you do call them, they will give you the directions. But in any case, the address is 14 Claypole Road, Stratford, E15 2RJ. E15, that's East 15 to Romeo Juliet. So do make note. This legal hour was with Abinelle Solicitors and with Amy. We'll do it again, same place, same time next week. Until then, look after yourself, and we'll see you next week.